Now this is very important. This has not been shown to your lordship. Just give me a minute. 398 and 5 judges out of 9 say this. 5. First is Justice Jeevan Reddy with Justice Agarwal. The proclamation must therefore be held to be not warranted by Article 350 outside its purview. Cannot be said that the President was satisfied that the government of the state cannot be carried on. The action was mala fide and unconstitutional. The proclamation is accordingly liable to be struck down. And we would have struck it down, but for the fact that elections have since been held and a new assembly has come in. That's the only exception. Today the illegal government is running. There is no elections. Then, and the person who otherwise, suppose the lordship holds the governor to be bad, then a person not entitled to be holding the post of chief minister. How can, of all courts, the Supreme Court accept such illegality? If your lordship's powers are unique in this country, in that even your lordship's can go beyond the law. Not contrary to law, beyond the law. Then, what's the point if the governor's actions are held to be illegal? Actually, your lordships would be giving a Pyrrhic declaration and accepting that the illegality has borne the fruits of its illegality and people have enjoyed it. Now, let's just see next one. In state of Meghalaya, it's very interesting. For the other state in Bombay, para 12 of my note. Again, Justice Reddy said, but for the fact that since the proclamation, fresh elections have been held to the assembly. So suppose Meghalaya had not had elections and Karnataka had, they would have restored Meghalaya. We would have certainly issued the writ and directed restoration. Justice Sawant for himself and Justice Kuldeep Singh, our conclusions may be summarized. However, in view of the fact that fresh elections have been taken place and new assemblies have been constituted, all no relief is granted consequent upon the declaration. Therefore, this is the heart of this point. Now come to page 1 on 189. The third point is 189. That is coming separately. That's coming separately.
What is the point, Dr. Singhvi?
Yes. Now, a very strange argument was raised, de facto doctrine. Regularization and validation by 189. Mr. Salve argued at length. Mr. Mehta also argued.
Page 189. I'm sorry to interrupt. What is 189?
No, page 1.
Page 1 of my note. That is the de facto doctrine that actions validated by the actual act which is challenged is illegal. I want to show how wrong this can be and how dangerous it is. Give me just 2 minutes. The case law makes it clear, but just come to the case law later. Just give me 2 minutes. The first important thing is to note that there are 2 kinds of challenges. One is a challenge to the very validity of the act. Come to para 8 of my note. So I challenge a validity of an act. Let us say the Governor's Act. Let me say competence of a legislation. Let me say fundamental rights. Versus the eligibility of certain people to act under the act, to sit there and act. Your lordship under 189 protects the second, not the first. If the governor's action is bad, will 189 ever protect it, Mr. Friends, 2 of them argued at great length on 189. Did they answer the question? Ultimately, the core question, my lord, is just formulated either way, this way or that way. Is the governor valid or not valid? If your lordship holds him to be invalid, 189 comes only after your lordship holds something to be invalid. Otherwise, it doesn't come into play.
189 is said in the context of the vote in the House.
So,
with respect to...
Exactly. So, therefore, no. 189, your lordships can and may, and in this case perhaps should, in the intervening period of 7-8 months, the decisions taken by an otherwise illegally constituted government may be valid under 189. That's the real commonsensical way of implementing it, I am not suggesting that somebody's appointment is quashed, somebody's transfer is gone, somebody's policy decision.
So what
Maharashtra government has made a liquor policy,
Dr.
therefore
CP,
that is gone.
What saying is that Article 189 recognizes a de facto doctrine.
De facto doctrine.
What the de facto doctrine does is to legitimize the acts of an authority whose original appointment is found to be invalid.
Subsequently found to be
invalid. Correct. But that does not validate the original appointment itself.
That's the one sentence pithy summary. Just give me a minute. Come to D, 8D. 8D. Or calling for, that goes back to the same thing. First act was what? The governor being approached, governor calling. The 2 others are consequences. Voting is a consequence of the governor's illegal act. So is the oath taking. If the original act is bad and your lordships can't validate it, then this will not validate the vote. The consequence is bad. The consequence of an illegal origin cannot validate the illegal origin. And similarly, 189 cannot Sorry.
What you're saying is that if the calling of the voting in the house itself is subject
That's
to
just how my lords formulation was, right or wrong. Governor's action, A, no basis, and B, if basis, it is wrongly applied, etc.
but that's affirmation of the house, right? Then what? I mean, I still have it.
Affirmation is coming. That's this section. Bomai dealt with the affirmation.
All right.
Bomai said, we hold something to be illegal. Let's kindly give me a minute. This is very interesting. But thereafter, Parliament has approved it. Exactly the same thing. How can we quash it? Said, no, sorry, will be quashed. Can you come to that now? So first, let's come to, yes, I'll just show 50. Just keep 356 Sima's query answered by Bomai. Para 4 of my note, this note. Much worse, fellas. Here there was nothing, in our case there was nothing. There was a presidential proclamation affirmed by Parliament in Bomai. Now come to para 4. It is respectfully submitted that the said contention is misconceived, liable to be rejected. In Bomai, does my lord have it? Para 4. Do my lords have it?
Yes.
Yes.
Considered the effect of approval of a presidential proclamation by both houses on the legal validity of the proclamation when it is questioned before the Constitutional Court, held a clear majority, 5 judges, that if a proclamation on 356 is invalid, the same as liable to be set aside even if it has been subsequently approved by both houses. Your lordship is told 289, 189. This is express approval. This is express approval. Now read this para. Very interesting. 110 Justice Sawant for Justice Kuldeep Singh.
We'll check this up. We got the point. I mean, you're saying that the Bombay has a.
Now there is one interesting, very interesting. After 29 years and 2 days, this is happening in a lordship's court. This para 110, that bold-face line by Justice Sawant says invalid. Lordship got the second line underlined.
Yes.
All the books say it's valid. SCC. SCR correctly says it's invalid. SCC for 29 years and 2 days called it valid.
I hope you're citing our ESCR, Dr. Singhvi.
No. We've checked up. Then they issued a corrigendum. When my learned friend's colleague here, sitting here, pointed it out. Then the SCC. Now, the word invalid here is by corrigendum the correct word. It is in the SCC valid. So it can't be valid. Just note that. What is the legal consequence of actions taken by the President if the proclamation is invalid, yet it is approved by both houses? Come to 111, Lordship. See, I am racing only on the underlined portions. The proclamation will not make any difference to the legal status. Express approval. Forget 189. Parliament expressly approves. The action will undoubtedly be illegal. Then we'll skip 10 lines. There is no reason why the Council of Ministers and the Legislative Assembly should not stand restored as a consequence of the invalidation of the proclamation, the same being the normal legal effect of the invalid action. In the context of constitutional provision which we have discussed, and in view of the power of judicial review vested in the court, such a consequence is also a necessary constitutional fallout. Necessary constitutional fallout.
Get the point.
Unless such result is read, the power of judicial review is nugatory and meaningless.
There is a constitutional permissible. It's permissible to have a complete restitution. Is what you're saying.
Otherwise, it's meaningless and nugatory. The 9 judges say that. And next sentence highlighted. Hence, the necessary consequence of the invalidation would be the restoration of the ministry as well as the Legislative Assembly. Then para 114, boldface. Secondly, the court may invalidate the proclamation whether it is approved by Parliament or not. The necessary consequence of the invalidation could be to restore the status quo ante. Therefore, to restore the Council of Ministers and the Legislative Assembly as they stood on the issuance of the proclamation. So, if your Lordship is otherwise convinced, your Lordship needs no support than more than a 9-judge bench, which is very clear. It may, however, to be made clear, next sentence is very important, next boldface. It is, however, to be made clear that the interlocutory relief that may be granted on such challenge to prevent frustration of the constitutional remedy. It is not to prevent the constitutional authority from exercising its powers and discharging its function. And then to conclude, the court in appropriate cases not will be justified in preventing holding of fresh elections, but will be duty bound to do so by granting suitable interim relief. Then, they summarize the conclusions, which I will not read to save time. Clearly, para after para is devoted by Justice Sawant and Justice Kuldeep Singh. And just see 7, another phrase, molding of relief, big Roman 7. Otherwise, what's the point your Lordship is exerting so much? If your Lordship comes to that conclusion with great respect, and that to a court with 141, 142 and special powers, I can understand the High Court possibly flinching. According to me, even the High Court has the power to do it under your Lordship's judgment. Now, Justice Jeevan Reddy said this, even in case the proclamation is approved, it would be open to the court to restore the state government to its power. If this were not conceded, look at these words, 9 judges. 29 years ago. If this were not the case, the very power of judicial review rendered nugatory entire exercise meaningless. The court cannot grant the relief flowing from the invalidation. It may well decline to entertain. Well, they say if you can't grant the relief, why did you entertain? That's what this court is saying, 9 judges. And then Justice Pandyan, just 2 lines above 4A, I find myself in agreement with the opinion of Justice P.B. Samant on conclusions 1, 2, 4 to 8. This includes my conclusions, which I have just read, 4 to 8. So this is, the 3 points are covered: prohibitory, affirmative, 189, and resignation. Now, the 4th point is this prospective and retrospective of the EC. They're all important queries which fell from my Lord. My Lord the Chief Justice asked this question more than once.
That is C.
That is my C, my Lord is right, pages 8 to 10.
Page 8.
Just forget everything else. I'll take one point here is enough. Whatever else your Lordship holds, on the bare text, textually and facially, symbol order number 15, has to be prospective. Forget all we'll come to the interpretation. Just read the text facially. That's at para 15A of my note.
Yes.
Without anything more. We'll come to the consequences. As drafted facially, without any interpretation, it has to be only prospective. Kindly read. Power of the Commission in relation to splinter groups. Now, I've underlined some words. I've taken the liberty of underlining some words. When the Commission is satisfied on information on its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party, the Commission may, after taking into account all the available facts and circumstances, and hearing such reps of the sections or groups and other persons who desire to be heard, decide that one such rival section or group or none of such rival groups shall be binding. This cannot but be futuro.